morning everyone. My name is Utsavadikari and my student ID is EMB21089. Today I'm going to discuss on a topic of Canada versus Australia measures affecting importation of salmon. This is our topic for a group presentation and we have 5 team members in our group. Let's begin with the dispute. In 1975, Australia imposed a ban on imports of freshwater salmon under a quarantine regulation that prevents the entry of the imported diseases to the fish market. And meanwhile, Australia also allowed to continue imports of non-fresh salmon, including the salmon that has been heat treated by canning or smoking. They said that it reduces the risk of disease. But the tension arises between two countries, Australia and Canada, in 1990s, where Canada blamed that Australia is implementing those regulations without any scientific evidence, while the Australian says that the ban was justified by the health grounds. In 1995, the annual growth of the Australian salmon industry was around 75.1 million US dollar, with a total salmon exports of around $40 million. In 1995, the annual imports to the Australia of the salmon was around $52 million, which is almost half of those amount the salmon came from the Canada. And Canada has a very bad impact on their trade due to the Australian restrictions. In 1995, Canada lodged and complained to WTO against Australia. Said that the Australia is violating various rules and regulations of GATT agreement and the WTO SAF agreement and SAF agreement. So those disputes started between the Canada and Australia, and further discussion will be given by my friend Aditya. Thank you.
Hello friends, my name is Aditya Khanal. My student number is EMV22547. From now on, I will discuss on the legal issues of the dispute between Australia and Canada regarding the importation of salmon. So basically, the issue started after Australia prohibited the importation of salmon in their country, and as a result, Canada lodged a complaint to WTO, which is World Trade Organization, stating that Australia has violated the terms of SPS agreement under the articles 2.2, 2.3, 5.1, 5.5 and 5.6. In the SPS agreement, it is clearly written that either party, either Australia or Canada, can enforce some restrictions related to trade to protect humans or any form of life in their country from unexpected diseases. So Canada has to conduct various preventive measures so that there will not be any risk regarding the outbreak of unexpected diseases in Australia. And they have done that and followed all the protocols, but still Australia denied the access of salmon, which is not legal. And after accepting the agreement, if you do that, then that is against the law, and it has created a big issue in international market. So but the interesting part is Australia argued about the complaint of Canada, saying that we have banned salmon to protect our marine life, but they did not ban other fish products which carry an equal risk of spreading exotic diseases. So if they had the concern about the spreading of diseases, then they would have banned other fish products as well. So they couldn't prove that point, and ultimately found guilty by the WTO settlement panel, and they were forced to conduct a new import risk analysis, which resolved the issue finally. So that is all from my part. My friend Sunita will continue with the next part. Thank you very much.
Hi, my name is Sunita Gurung and I'm going to present the individual parties' argument of Canada and Australia. In the year 1994, Canada first lodged a complaint to the World Trade Organization regarding the import restriction of Australian in fresh, frozen and uncooked salmon, where Australia stated it as a measure to prevent the spread of exotic disease. However, the Canadian Food Inspections Agency verified that exports, foods and food products met the Canadian standard as an importing country for uncooked frozen salmon and other products. However, later Australia imposed an unreasonable ban on uncooked salmon import from Canada, clarifying that it is likely to prevent the introduction of any infectious or contagious disease affecting persons, animal, or plants. Not by complying, Canada added that the measures were not developed and applied as per sanitary, not complying with the international standards. Further, the measure by Australia did not meet the condition of Article 5.1, 5.5, and 5.6 of SPS, and the measures were not based upon the adequate assessment and scientific evidence regarding health risk of Canadian imported fresh, frozen, or uncooked salmon. On Canada request on the access of uncooked salmon in Australian market, Australia conducted a risk analysis and reported that certain products cannot be imported without a subject of treatment to protect indigenous fish species from exotic disease and was therefore permissible under the SPS agreement. WTO established a dispute settlement panel in 1997 to resolve the issue. Australia claimed that the panel should first examine the consistency of Canada's claim with the SPS argument. Additionally, Canada should be able to demonstrate that Australia's measure violates GATT 1994 argument of trade. Australia claimed that its measures were in accordance with the obligation of SPS. Australia further claimed that the panel terms of references did not extend to Canada's claim of non-violations and impairment under article. Thank you.
Hi, my name is Dipendra Sunar. My student ID is AMD2980. I'm going to discuss tribunal decision on Canada versus Australia on importation of salmon. Canada complained about the quarantine restriction that Australia was imposing on its product. The World Trade Organization therefore formulated a panel to look into the issue of Australia-Canada trade in salmon. So they decided, and Canada requested to access Australian market to give salmon or its product for human consumption or various research-based reasons. Australia had failed the agreement. Article 5.1 and 2.2 has been breached by Australia. Additionally, Article 5.5 and 2.3 provision under the same agreement and made it difficult for the other parties to lay trust. They formed an appellate body which found sufficient findings based on the fact Australia breached 5.6, 5.1 and 2.2 of the same SPS agreement through importation to some part of Tasmania. This report therefore tabled as proof of Australian non-conformity to the SPS agreement that had been signed earlier on. Thank you.
Hi, my name is Pragya Machi and I'm here to talk about the importance or significance of the case related to salmon importation between Australia and Canada in the international law and other development from the tribunal decision. At the end of the case, Canada was favored by World Trade Organization and SPS, where SPS stands for sanitary and phytosanitary measures. As a result, Australia promulgated a new guidelines in salmon importation in accordance with WTO and SPS requirements. The case not only solved the salmon import dispute between Australia and Canada, but Australia was asked to set new guidelines in the import of other fish species that met the WTO and SPS guidelines. The guidelines formed the basis on fish import from any other countries to Australia in the similar circumstances. This case also helped in other similar disputes which was once happened between Japan and European countries related to meat and meat products export and import. In addition, the case concluded that it is essential for Australia to comply with the requirements in respect to the safety and correctness assessment before applying any import or export ban of goods while trading in the international market, which can be a very important analysis in the international law. The response of dispute panel in this case provided that an international law should protect health of both the people and animals. However, the law can only be imposed after proper risk analysis. So, in this lecture, we talked about the case related to the salmon importation dispute between Australia and Canada, where Australia imposed a import ban from for the salmon import from Canada, which are fresh, chilled, or frozen. However, the result favored Canada, and it can be a very important analysis in international trade because it helped to solve other international disputes and also provided an important guidelines in the tribunal decision, which can be helpful in similar cases in the future.